Hello, this is Dane Ciolino, and this is Class 21 on the evolving business of the practice of law. This class is another one of these kind of squishy classes, to the extent that it's not really about a lot of hard rules and doctrine, although we're going to deal with rules 5.4 and 5.5, which are testable on the MPRE, and which are rules that have given rise to a lot of recent discussion in the legal profession, in the organized bar, and have led to some disciplinary actions. So we're not going to be wholly talking about just kind of general trends and recent developments in the legal profession. We're going to also focus on some doctrine that is going to be important to you on the MPRE. So where are we? Well, in the first lecture of this subpart of the course on the evolving practice of law, we dealt with issues related to the developments in the regulation of law practice. We dealt with our acronyms, the UPL, Unauthorized Practice of Law, MJP, Multi-Jurisdictional Practice, and MDP, Multidisciplinary Practice, and talked about how lawyers are teaming up with non-lawyers, how they are crossing borders more than ever before, and how non-lawyers are starting to want to invest in law firms. And then most of all, we talked about advertising and solicitation. In this class, we're going to deal with a number of kind of related issues, but we're going to focus on changes in private law practice. We're going to talk about globalization and economic and technical changes in practice. We'll talk about temporary and contract lawyers. It used to be that the only lawyers who worked at a law firm were associates and partners. Well, not so much anymore. We'll talk about lawyers working out of retail stores. Could Walmart, for example, set up a little lawyer in a box section and have people go get their wills and their personal injury cases tended to while they're shopping for clothes. Then we'll talk about onshoring and offshoring and onshoring, outsourcing legal services. And then finally, we'll wrap up this discussion and this portion of the course by talking about new methods of financing legal work.
Technological change. Now, there have been technological changes in the law practice, well, for years. I mean, lawyers used to dictate to their secretaries what they wanted their briefs to say, and the secretaries would type out the briefs on manual typewriters, later electric typewriters, and they would use carbon paper and whatnot. Now, of course, in the late 70s and early 80s, lawyers started using word processors, and then later cell phones, fax machines, the internet, email, online data storage. So there have been a lot of technological changes. So what is the rule on this? Well, Rule 1.1, of course, is the basic rule on competence. And of course, we all, in order to be competent, we all have to keep up with the law, and we have to do a good job on learning the facts of our cases. But in the late 2010s, the ABA added a new comment to Rule 1.1 that said a component of being a competent lawyer is keeping up with relevant changes in technology. More particularly, the model rule, the comments, comment 8 to model rule 1.1 now says this, that a lawyer to maintain competence has to keep up, and here's the language, with the benefits and risks associated with relevant technology. Now, what does this mean? Well, it doesn't mean that you have to buy the latest iPhone 11 Pro Max. I have that phone, but not everybody needs that phone. What it means is that you need to at least keep up with the types of technology that can help your clients, make you a better, more efficient lawyer. For example, some lawyers say, I don't do email. That's inappropriate. To me, that's incompetent. You have to keep up and use email in your practice. Now, does it mean that you have to use all the latest whiz-bang technology? No, but email, yes. Now, some technology, faxes are really on the way out. Why would you continue to use a fax? Nothing incompetent about it, but you need to get up to speed on scanning and emailing instead of faxes. I really liked when this article came out, this change came out, because it said that you can't be a dinosaur. It's not competent lawyering. Okay, so the bottom line, the takeaway for you on this is be competent with the basics of law technology and remain competent. All right, let's talk now a little bit about the globalization of law practice, and particularly outsourcing, offshoring, and onshoring. And take this question. Is it okay to ship legal services over to India? We all know that lots of manufacturing is done in China, lots of kind of high-level, white-collar work is done by people in India. And the world is a lot smaller place because of the internet. It's a lot easier to ship off work overseas and get it done while have someone who's awake in Pakistan do the work while you're sleeping in New York City. So what are some of the rules that govern this? The starting point for this is Rule 5.5 on the unauthorized practice of law. And here's the basic provision, that a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction or assist another to do so. So let's take the most basic hypothetical. You, if you're licensed in Louisiana, can't just go to Mississippi and start practicing law. Why? Because you're practicing law in that jurisdiction in violation of the regulation of the legal profession in Mississippi. Conversely, if a Mississippi lawyer came to Louisiana, you could not assist them to practice here. Why? Because you'd be assisting them in violation of the Louisiana regulations on unauthorized practice of law, or UPL to use that acronym. Now, does that mean that you can never go to Mississippi to work on a case? No, I didn't say that, because after all, there are times when you can go to Mississippi temporarily. Then it's not UPL, it's permissible MJP, multi-jurisdictional practice. Paragraph B then goes on to deal with kind of other situations. And take this hypothetical, because this is one that's come up several times in my consultation work. Suppose you have moved to New Orleans because your spouse used to be a resident at a hospital in New York City, but they've got transferred here, they've got a new job now, and they're on staff at Ochsner. So you are a kind spouse and move along with them. But you're not admitted to practice in Louisiana. You're a New York lawyer. In fact, you've been at that New York law firm for 5 years, and you've left the firm. And this is the question. Can you now continue to practice law for that firm in New York here in Louisiana without taking the Louisiana bar and being admitted in Louisiana? And the rationale might be this. I don't need to know Louisiana law. I'm not practicing Louisiana law. I'm doing my federal antitrust work or my New York consumer protection work. I'm practicing federal and New York law, not Louisiana law. Therefore, I don't have to be admitted to Louisiana. Does that argument hold weight under 5.5b? The short answer is no, because a lawyer who is not admitted to practice in this jurisdiction, Louisiana, shall not establish an office, including a home office, or establish other systematic and continuous presence in this jurisdiction for the practice of law. I know you're not hanging a shingle outside of your home office, but it is still an office. And even if it weren't an office, you still have systematic and continuous presence here. And that's the law, unfortunately. Does it make sense? No. Do I think that lawyers should be able to practice with their New York firm while sitting at their desk in Metairie? Yeah, I think all that should be okay. And some states have gone in that direction from a regulatory standpoint, but not the ABA model rules. Under the current rules, you are engaged in a systematic and continuous presence physically here in Louisiana. And even though you're not practicing Louisiana law for Louisiana clients, you're still physically here practicing, and this rule would be implicated. And then finally, 5.5b, of course, says you can't hold yourself out to the public or represent that you're admitted here when you're not. That's fairly obvious. That is not only a false or misleading statement that would violate the 7 Series rules, but it also would be UPL. Temporary and contract lawyers. You know, there was a time where when you joined a law firm, you were an associate and ultimately you would become a partner and you'd never leave that law firm. All the lawyers who worked at the firm were full-time employees or equity owners of the firm. Well, those days are no more. It's not uncommon for a law firm to get lawyers temporarily engaged for just a week or a month and have them do a document review, for example. And they bill them out and make money off the lawyers. And then after the document review is over, the temporary engagement ends, the contract concludes, and then the lawyer's back on the streets looking for another temporary or contract job. Now, that's just a reality of the modern law practice. Is there a lot of this? No, but firms that do these big tort cases often will hire these temporary contract lawyers. So what do you need to know about them? Well, this is the one principle, really, and this is the most important takeaway. A lawyer who's temporarily or just contractually associated with a firm for a brief period is still, quote, associated with the firm, in the sense that the conflicts that that lawyer has are going to be imputed to the firm, and vice versa. Just because you're a temporary lawyer doesn't mean that the rules of imputation don't apply. You are associated with that firm, and as a result, all the imputation rules are going to apply. That's the most important takeaway. Relatively kind of interesting case came out in the last couple of years, and it asked this question: is overtime pay required for contract lawyers who do mindless document review? And this was the issue. A big law firm in New York decided that it just had a bunch of lawyers that were just looking at documents. They said, well, you know, a machine can do what these lawyers are doing, so we don't want to have to pay them overtime. Well, they argued that, you know, these were just situations where the lawyers were not lawyers, but they were billing them out as lawyers. What did the case say? Well, here, a fair reading of the complaint in the light most favorable to the temporary lawyer, Lola, is that he provided services that a machine could have provided. The parties themselves agreed at oral argument that an individual who, in the course of reviewing discovery documents, undertakes tasks that could otherwise be performed entirely by a machine cannot be said to engage in the practice of law. He, according to this opinion, was going to be able to receive overtime pay. Why? Because lawyers who exercise legal judgment are not the kinds of employees who are entitled to overtime. You could ask that to any grunt at any big law firm in New York who's grinding away and not getting overtime. But this case interests me because if the lawyer's not a lawyer, you could bet that the law firm's billing him out at lawyer rates. So the firm's probably talking out of both sides of its mouth. On the one hand, they're saying we don't have to pay you overtime because what you're doing could be done by a machine. On the other hand, they're probably billing the lawyer out at lawyer rates. So again, just quite an interesting notion. And the only reason I share this slide with you is because it's one of these current issues that relates to temporary and contract lawyers. Lawyers in retail stores. Could you set up in Walmart a little lawyer in a cubicle and have people go over there to the lawyer and get their wills done or get a divorce? Now, this is an issue that's come up several times, and it presents this fundamental notion. Is it okay for a lawyer to work for a non-lawyer, like Walmart is a non-lawyer? Is it okay for a lawyer to share fees with a non-lawyer. Because after all, if somebody comes to the lawyer to get a divorce and pays the lawyer, even if the lawyer's at Walmart, the lawyer is paying, the client is paying for legal services. So can the lawyer then share that fee with Walmart? And that's the fundamental issue. And here's the principle. Under 5.4a, a lawyer generally cannot share legal fees with a non-lawyer. That's the general rule. And this is all about professional independence, as the name of the rule suggests. So a lawyer or law firm shall not share legal fees with a non-lawyer except. Now, these exceptions don't apply very often. Like, for example, if a lawyer dies, then money can come in and go to the estate or to the heirs. If the lawyer is getting out of the practice of law, the lawyer can sell his practice under 1.17. There are retirement plans that allow the sharing of net profits with a non-lawyer because the firm sets up a profit-sharing plan. And then court-awarded legal fees with a nonprofit organization. If you're doing work for the ACLU and you win your case, you can share some of those fees with that nonprofit organization. But again, these exceptions are few and far between. The short answer here is that generally a lawyer cannot share fees with a non-lawyer. So what does that do for our lawyer in a box at Walmart? Well, not much. It pretty much means that the lawyer can't do it, essentially. That at this point, the lawyer is going to be, that's why we don't see lawyers. Even though we see tax preparation at some of these big box stores, we see dentists and doctors and pharmacists, other professionals, plying their trades in these big box stores. We don't see lawyers for this reason, because there's no way to structure the relationship in order to allow the lawyer to share legal fees with the big box store. And this is yet another kind of implementation of this principle of professional independence of the lawyer. Not only we've just looked at A, that says the lawyer can't share legal fees. B says a lawyer can't form a partnership with a non-lawyer if any of the activities of the partnership consist of the practice of law. Now, can a lawyer go have a contract with people who are non-lawyers? Yeah, of course. So, for example, and I had this conversation recently with a law firm in Baton Rouge that wanted to set up a relationship with lobbyists. They wanted to bring the lobbyists in the firm. Now, they can't be in the partnership. They can't own the law firm, but what they can do is they can set up in its own silo, essentially, a lobbying subsidiary, a new LLC, and then within that new LLC, they can provide lobbying services, which are not the practice of law, and then they can share those lobbying fees that are earned by the lobbyists, so lobbyists can share their fees with lawyers, but the converse is not allowed. That is, the lawyers aren't going to be allowed to share their fees with the lobbyists. So again, you can form partnerships and business relationships. If you had a law firm and you wanted to also have a landscaping company, that would be fine to share landscaping fees with lawyers, but those landscapers could not be partners or equity owners in the law firm. They can be contractors of the law firm, but that's about it. Also, a lawyer shall not practice with or in the form of a professional corporation or association authorized to practice law for a profit if a non-lawyer owns any interest therein, except that a fiduciary this is kind of a dead lawyer problem. Estate of a dead lawyer may hold stock for a reasonable time during administration. A non-lawyer is a corporate director or officer thereof. So again, we don't want non-lawyers being in charge of law firms, and we don't want non-lawyers having the right to direct or control the professional judgment of a lawyer. Again, we want lawyers to run law firms. We don't want non-lawyers to be directors or officers of law firms, even if they're not owners. We certainly don't want them to be owners, and we don't want generally them non-lawyers to have the right to direct or control. Now, what have we seen recently in this? There have been some silly ethics opinions out of Texas that have suggested you can't call a non-lawyer an office manager because that would suggest that they have the right to direct or control the professional judgment of a lawyer. Well, that's just plain silly. Everybody knows the office manager doesn't run the law office. They manage the pencils and the toner cartridges. I mean, not to diminish what an office manager would do, but they don't practice law. That's the point. There's no interference with professional judgment when an office manager, and the Texas, to its credit, the Texas Bar Association corrected that opinion. But it's a good illustration to see what the problem is. We just want to keep lawyers professionally independent. Now, here are a couple of interesting situations that put some gloss on how these principles work in practice. Text a lawyer. How does it work? Well, we all have apps on our phones. The prospective client gets an app for a phone. Suppose you want to get a divorce. So you get an app. You download Text a Lawyer. And you select the state and the legal category. So if you're in Louisiana, you just say Louisiana domestic law. And then you're instantly connected to a lawyer on the app. The customer pays $20 to Text a Lawyer, and Text a Lawyer pays the lawyer $15 and keeps $5 as an administrative fee. Now, is that ethical? Well, I'm not sure. It really depends on exactly how it's structured, but it sure sounds to me like the client pays a $20 fee and the lawyer pays $5 of that fee to Text a Lawyer. It sounds to me like fee sharing. Something similar to that is Avo Advisor. Now, Avo is, of course, we've all heard of Avo. Avo is an online, it's kind of like a Yelp for lawyers, for those of you who have not seen it. Traditionally, lawyers, the lawyer directory that historically for years back in the days of print that lawyers would use was called Martindale-Hubbell. More recently, Avo is the biggest player on this scene probably, and they set up a new service called Avo Advisor. And what is it? Well, a prospective client goes to the Avo website, selects the legal service they want. Like, for example, maybe they want to talk to a lawyer about domestic work. Again, you want to get a divorce, you want to talk to a divorce lawyer. Avo then arranges for an experienced lawyer to call you right back. Avo sends the lawyer 100% of the client's payment. So if you talk to this client for 15 minutes, the lawyer would get $39. But then the lawyer is obligated to pay back a marketing fee of $10 to Avo. So the lawyer only makes $29 for the 15-minute talk. But the question is that ethical? Well, I don't think so. Under the Utah advisory opinions, South Carolina, Ohio, the fact that there's a separate transaction in which the service is paid doesn't mean that the arrangement is not fee splitting. It is fee splitting. A lawyer can't do indirectly what would be prohibited if done directly. Allowing Avo here to take a portion of the attorney's fees, and that's what's happening here, a portion of the attorney's fee by disguising it in two separate transactions does not avoid the problem. And the problem is fee sharing between a lawyer, legal fee sharing between a lawyer and a non-lawyer. You just can't do that. Okay, new methods of financing legal work. And when you watch cable TV, you see lots of litigation financiers, people wanting to help or buy settlements from people or help people finance litigation. And lawyers like this because lawyers don't want to come out of pocket for a lot of money to pay for doctors and experts and filing fees and depositions. So to what extent can litigation funders play a role in this? And lots of questions have arisen since the late 2018, 2019 time frame about the extent to which it's okay to have litigation funders participate in ongoing litigation. Well, the bottom line on this is, can they do it? Yeah, but the structure matters. This is so true. You could say this about so many things in law. And this is a question that the New York City Bar addressed in a July 2018 advisory ethics opinion. Is, may a lawyer enter into a financing agreement with a litigation funder, which is a non-lawyer litigation funder, under which the lawyer's future payments to the funder are contingent on the lawyer's receipt of legal fees or on the amount of legal fees received in one or more specific matters? The short answer here is no. Why? Because under 5.4a, you can't share legal fees. Now, having said that, you could structure the arrangement so that the money is paid by the client, right? If the litigation funder has a deal with the client to receive a share of the client's proceeds, no problem with that. The problem is that the litigation funder can't receive a share of the lawyer's proceeds, and that's where the problem was. All right, well, that's about all I want to say about these issues. As I said, this is really not heavy on the doctrine, although 5.4 and 5.5, those provisions that we talked about in this lecture and those that we talked about in the preceding lecture, of course, all come into play and are all testable on the MPRE. But I do think that this gives you just some bit of a flavor of some of the discussion that's going on in the organized bar and in the legal profession about the extent to which lawyers can engage in cross-border practice, to the extent that the lawyers can engage in business relationships and associations with non-lawyers. And you all will be lawyers in just a couple of years, and all of these issues will continue to develop throughout your careers.